Hello, welcome. I'm Cary Coglianese. I'm a professor at the University of Pennsylvania Law School, and I am the director of the Penn program on regulation. I'm delighted to welcome you to today's webinar. The Penn program on regulation links together more than 30 faculty from across the University of Pennsylvania who work on a range of issues related to regulation, covering topics from finance to environment, energy to transportation. We are also the proud sponsor of a daily digital publication, The Regulatory Review, and most pertinently, we're the sponsor today of our webinar along with the University of Pennsylvania Law School and its Model Initiative for Government and Public Affairs. The basic plan for the webinar today is first to hear from our guest speaker, Richard Cordray, about his new book, Watchdog, on the founding and early history of the Consumer Financial Protection Bureau. Mr. Cordray will share some initial remarks about his book, and then we will entertain your questions and have a discussion with him. I would like to encourage you to use the Q&A feature that's found on the ribbon down at the bottom of your screen to post questions that you would like me to pose to Mr. Cordray. I will then select from those questions and ask them, and note that you will not see the questions yourself, but I will try certainly to get to as many of these questions as I possibly can in our available time. If you would have any dialogue you'd like to engage in or comments you'd like to share with everybody participating today, you can do that by sharing your comments on the chat feature of Zoom. Of course, please do keep your comments on the chat function pertinent and appropriate. Members of the Penn Law event staff will be moderating the chat room, and anyone they deem making inappropriate comments can be removed from the session. But again, keep in mind that you should send along questions for me to ask Mr. Cordray via the Q&A feature found by placing your cursor over the ribbon at the bottom of your screen. Three other brief announcements at the outset. First, we are recording this webinar for post-webinar publication on the website. Second, for those of you who are attending today and are seeking CLE credit, the first passcode you need to know is GOAT, G-O-A-T. You will need this code, this first code, and a second one to receive your CLE credit. The second code will be given out near the end of today's session via the chat room. So again, the first passcode is GOAT. The second passcode will be displayed in the chat area toward the very end of today's session, shortly before 5 p.m. And third and finally, I want to thank Anna Gavin and the rest of our Crackerjack events and IT staff who have made it possible to bring us all here together today. With those details at hand, it now gives me great pleasure to introduce our speaker for today, Richard Cordray. For those of you who are joining us from Ohio, you are well familiar with Mr. Cordray, who was the Democratic nominee for the governor of Ohio in 2008. Previously, he served from 2012 to 2017 as the founding director of the Consumer Financial Protection Bureau at the federal level. And before that, he served variously as Ohio's Attorney General, Solicitor General, and Treasurer. Earlier in his career, he was an adjunct professor at the Ohio State University College of Law and a state representative in the Ohio House of Representatives, among other positions, including, I might add, a clerkship on the U.S. Supreme Court. Over this past year, we've been delighted to have Cordray spend time with us at the University of Pennsylvania Law School as a distinguished policy fellow. So we are welcoming back, delighted to welcome him back here to talk about his recently published book, Watchdog, How Protecting Consumers Can Save Our Families, Our Economy, and Our Democracy. I highly recommend the book, and I'm very much looking forward to our discussion today around it. Rich, welcome back. And can you please start us off by telling us about your new book?
Sure. Thank you, Cary. And I want to thank especially Penn Law School and the regulatory review staff and those involved, because I have, as you mentioned, spent time at Penn Law working on aspects of the book and have done several talks where I benefited from people's input as to different pieces of the book. So the book is Watchdog, and that was a term somewhat affectionately coined by President Barack Obama, who was a tremendous supporter and champion of the Bureau in its early going. And as he described it, what we needed was a watchdog on behalf of consumers in the financial marketplace. And this is an interesting feature of life as we know it today in the United States. We've had a consumer movement for more than a century in America, trying to help people in the marketplace figure out what they're buying, making sure of its quality, of its quantity, that things are fair, that they're not being cheated in the marketplace, that the price is fair and reasonably transparent to people. But it is a more modern phenomenon, as you and I have discussed, that we've had this explosion in consumer finance really since post-World War II. As I say in the book, and the book is about consumers, consumer finance, and ultimately the development of the Consumer Financial Protection Bureau and some of the political and legal and consumer fights that we took on there to try to improve the marketplace. But in terms of life of the consumer, it's changed dramatically over the last 2 generations. Our grandparents had very little credit available to them. But what's happened is consumer credit has been made available on a mass basis to people. You stop and think about the fact that we have a mortgage market that is now huge. It is in excess typically of $10 trillion, give or take fluctuations in value on a monthly basis. We have student loans, which really didn't exist on a wide scale when I was going to school a generation ago, but now is a total indebtedness for the American public of more than $1.6 trillion. We have auto loans and we have credit cards, and revolving credit cards with general credit available at many places to make purchases, again, didn't exist 2 generations ago, but now it's about $1 trillion obligation of consumers on the whole. To give you a sense of the magnitude of this development of the mass availability of consumer credit, President Kennedy gave a speech in 1962. Now, this was before things like the Truth in Lending Act and the Equal Credit Opportunity Act and all of the later consumer statutes that didn't really come around until around 1970 and in the decade or so since, and actually been a number of laws passed in the years since. But President Kennedy noted in 1962 that consumer credit was actually starting to be available on a broader basis. And at the time, he noted that it had tripled in size over the last decade to $200 billion total for the American consumer, which was an average of about $500 per person in the 1950s. Now, today, the most recent figures from the New York Federal Reserve Board are that the amount of consumer credit stands at about $40,000 per person in the American economy. So consumer finance and consumer credit are a much larger feature of our lives. And that has meant a couple of things. Number one, it means that our financial lives are much more complicated today. We have, typically we're juggling credit card bills, credit card revolving credit, maybe a mortgage, often a car loan, for many people, student loan debt that drags on for years and even decades. And we have other instruments available to us. We also have some subsidiary markets, debt collection and credit reporting markets, that are huge now. In the credit reporting market, the major companies have files on 200 million Americans, including almost certainly everybody on this call. in terms of your credit history, any defaults, any late payments you've made. And all of this is used to assess your credit worthiness. When you go to get credit, when you go to get any kind of a loan or a credit card, they will assess, your likelihood and willingness to pay, and they will charge you more or perhaps block you from having credit altogether, depending on what those files say. And debt collection has become a computerized market as well. At any given moment now, about 70 million Americans have one or more debts in collection. That means you may be being harassed by debt collectors on the telephone or over the internet or the other means that they can have at you. And that's become a more of a staple feature of American life. In addition, it makes our consumer financial lives more difficult in the following way. Whenever you go to make a big purchase, whether you're buying a house or in many cases buying a car or a truck, or if you're trying to finance higher education, you almost certainly are doing that on credit. And you need to understand not only the product you're buying, are you going to go to Penn? Are you going to go to some other institution? But also you're going to have to decide how you're going to finance that. And that's a decision that won't be made just one time, but it'll last you for years and years of your life and be a dominant feature in your life. And it will affect other decisions you will then be able to make and other options that are available to you. So that's one of the interesting changes that has occurred in the last couple of generations. Now that leads us to the fact, and I talk in the book about the fact that in the wake of the financial crisis of 2008, there was a perceived need for reform of these markets. And one of the reforms that Congress settled upon was to create a new Consumer Financial Protection Bureau to focus very specifically on looking out for the consumer in the financial marketplace and protecting the consumer against being cheated or mistreated in these markets for consumer credit. That was the new agency that I became the director of. I was recruited there by then Professor Elizabeth Warren, now Senator Elizabeth Warren, who was building the Bureau originally and who had conceived the idea for the Bureau before it was enacted by the Congress. She then recommended me to President Obama to head the Bureau as its first director. I talk about some of the political struggles we had because we were taking on the finance industry, which is a major factor in Washington, a major influence and power in Washington, has more to do with campaign contributions and lobbying expenses than any other segment of the economy, and we were taking them on. And so there were both political fights and legal fights, and our effort to get our arms around some of the major markets and try to improve them. A lot of that is the story of the book, but it starts with stories about individual consumers and what kinds of situations people find themselves in. And these are stories that, came to us at the Consumer Bureau from people and their families and their friends and the people in their neighborhoods. And they're common stories across America of people having trouble with credit cards or trouble with a mortgage or being behind on debts and being harassed by debt collectors. And we start with those stories to help illustrate that this book is really about every one of us. All of us are consumers. All of us are participants in the financial marketplace, and all of us are liable to being cheated or mistreated at various points in our life. And what do you do about it? And what can you do about it? And what does the Consumer Bureau do to try to even out and create more fairness in that marketplace? And that's much of what the book is about.
That's terrific. I really like how the book begins with some very concrete stories of individuals and their struggles with consumer finance. I would like to encourage anybody on the webinar now, certainly it's a good time to go into the Q&A function and type in any questions that you may have that I can relay to Mr. Cordray. Let me just start off with a little bit more about the title of the book, Watchdog, and ask about the role that this organization played as a regulator. Normally, I think, at least in the law school world, when we teach about administrative agencies, administrative law, and when we are focusing on administrative power, so much attention is given to the power of administrative agencies to make rules, to set rules. And yet I noticed at the end of your book, you mention, and you say that much of, and I'm quoting here, much of the Bureau's effectiveness came through enforcement and supervision of companies. And in fact, much of the attention and discussion in your book is of the CFPB as a watchdog in that sense, enforcer, a raiser of awareness, promoting public information, and less so on the actual making of rules. And I wondered if you could elaborate on that. Is that because so much law already existed in the consumer area that just had not been enforced adequately? And so when the CFPB was created, it really needed to just take on the role much more as a watchdog. I do know there were other rules that you worked on, so maybe you could just talk about the relationship you saw between the making of the rules, new rules, and then the enforcement role of the CFPB.
Okay, sure. And one of the things that was noteworthy to me is that Congress that created this new agency, the Consumer Financial Protection Bureau, had to devise a set of authorities and create a roadmap and a direction and a set of purposes and objectives to try to make that agency effective. Then, of course, it fell to us, those of us who were actually putting the agency together from scratch, frankly, and it doesn't happen very often that you build an entire government agency from ground zero, but that was part of our pretty significant job there. That we had to figure out how to take these tools and make them effective. And as you say, we had multiple tools to deal with the marketplace, and there were many problems that we found in the marketplace that had been not addressed or had been under-enforced, if you will. So there was both existing law that had not been enforced effectively, and we were trying to overhaul the enforcement mechanism so that we could bring actions against companies that were violating the law, not only to stop them, but to deter others and create a different dynamic in the marketplace so that people did feel someone was finally looking over their shoulder very carefully to make sure they were doing things right. And that was an important shift. We also had, as you described, the Supervision Authority, which is the authority to send in examination teams to really see what's going on from the inside, almost like an audit function. To be able to determine what's happening, is it being done right? If it isn't being done right, are consumers or customers being harmed? And if so, what needs to be done to put it right? And then also, as you say, we had authority to write new rules. And in fact, Congress had been very specific with the new agency in telling us that we were required to write at least 7 new rules, and actually there were more than that, but 7 new rules in the first 18 months to change things in the mortgage market, because the mortgage market, remember, had broken down under the weight of irresponsible and predatory lending in 2007 and 2008, and had ultimately crashed the entire economy. And so one of the things Congress was determined to see happen was that there were going to be reforms to the mortgage market so that that could never happen again on the same basis. And by the way, it's now interesting, we haven't gotten to this yet in this talk, but we're now in the midst of a new economic crisis. I have been saying for about a decade that the last crisis was the worst one we had seen in our lifetimes, and hopefully was the worst one we would ever see in our lifetimes. We now are in the middle of another very severe economic crisis. In some ways, it's been faster and deeper than the last one. It may not last as long, but we don't know that yet. But certainly there is, for the moment at least, high unemployment and consumers in a lot of distress, people behind on their bills, behind on their mortgage and rent payments, behind on their auto loans, and we have consumers in a very bad way again. But one of the things that has happened in the wake of the last crisis is new mortgage rules that were put in place to safeguard the mortgage market and make it work better have worked pretty effectively, at least thus far, and it is a better market. And that was in part because we did, as you say, we had to adopt new regulations, which changes the law in the area and sets new rules of the road for how the companies have to operate. Then, of course, we have the ability and the authority and the job, really, of enforcing those new rules to make sure that the market shifted in response to the reforms that were put in place. And all of that was a very big task for us, but I think it was a pretty successful task. And I actually, since you and I last talked, the Consumer Bureau has a case in the United States Supreme Court that concerns the constitutionality of its single director independent leadership. And one of the notable things to me, there were a large number of briefs filed in that case with the Supreme Court. One of them filed by the Mortgage Bankers Association, who said to the court, in effect, please, whatever you do in this case, even if you find certain aspects of the agency unconstitutional, do not upset its major work. The mortgage rules that have been in place in particular have made it a better mortgage market, have made it work effectively. We all have come to rely on those rules, and we'd hate to see them disrupted here. So that suggested to me that that was a compliment to the work we had done and a desire to see to it that it would endure.
And I guess, you know, we've got a question from Sabrina here to follow on actually your point about the litigation over the structure of the CFPB that's before the Supreme Court now. And there was, you know, legal uncertainty at the very founding of the agency when your appointment was made through a recess appointment, that not necessarily with the CFPB, but another case that went up to the Supreme Court that under that holding found that your recess appointment initially would have been unconstitutional. Fortunately, you, as you say in your book, a fascinating account of the politics surrounding the startup of the agency. You detail, you know, that you had a second, you know, appointment, and that was Senate confirmed by an overwhelming and bipartisan majority, at least to sustain the filibuster. But there has been controversy that's plagued this agency really from day one. And I'm wondering, and to follow on Sabrina's question, could you explain more about how and why the structure of the CFPB was chosen the way it was? And why have there been so many legal issues surrounding the start of a new agency that has been legislatively authorized?
Sure, and in the book, Watchdog, as you know, I tell actually inevitably there's a certain strain of political story that runs through it, because in the early days of the Consumer Bureau, it was almost like the perils of Pauline. We were in various crises from the beginning, partly because we had a job that was going to be very uncomfortable to some very powerful parts of the American economy. The big financial companies, the biggest banks, the other large mortgage and other financial companies, credit reporting companies, all of whom saw that we were going to be a new agency that was going to be a thorn in their side. We were going to be creating change. We were going to be costing them money. We were going to be changing the way they did some of the things that they were doing, especially those things that were not consumer friendly. And there was a lot of resistance to that. That resistance took the form early on of my nomination for the position of director was blocked in the Senate and was held up actually in the end for 2 full years. There were legal challenges to the agency, which have continued to sort of dribble on through the court system over the last 6-7 years. There were efforts in Congress to defund the agency and to overhaul the agency and change its leadership and to cut it back so that we would not be as able to exert ourselves in the marketplace. And by the way, one of the things that we knew from early on, and I talk about this in a book, it was a deliberate choice we made. We knew that if we went slower and if we did less, we would incur less criticism because there would be less reason for the powerful forces in Washington to be resistant to us. But we understood that the job we've been given by the Congress and the job we had under the law was to reform these markets and to improve life for consumers. And if that meant pinching the financial companies in various ways and taking on some tough fights, that's what we needed to do. It would mean more criticism, it would mean more congressional resistance, it would mean more battles in the courts, but that was an important thing for us to do, was to establish that the mission of this agency was a pro-consumer mission. For the very first time, you're going to have an agency in the financial marketplace that was going to be looking out for the consumer, not for the companies themselves. There's plenty of agencies that have been doing that, the Federal Reserve, Office of Comptroller of the Currency, FDIC, but this was going to be a pro-consumer agency, and our job was to look out for you and me and the people in our neighborhoods and on Main Street across the country, and that meant some tough political battles. Now, in terms of the structure and leadership of the agency, Congress made a determination, and this is within Congress's power to determine this in the first instance, that they wanted this agency to be headed by a single figure rather than by a board of colleagues, which is true of many of the federal agencies, as you know. That has become an interesting and unique legal challenge that is now in front of the United States Supreme Court. As you know, Cary, I was going to be coming to Penn to talk about this in the wake of having been in attendance at the Supreme Court on March 2nd when that case was argued. It will be decided very likely by the end of June, so within the next month or so. The term might go a little longer this year in the Supreme Court because they had some late arguments because of the pandemic, but that case will be decided fairly soon. My guess is it will change the leadership of the Bureau in the following way. It will make the director removable by the president at any time, much like a cabinet official is. That isn't to say that we remove cabinet officials all the time. It's a big undertaking to remove a cabinet official and set the department back and start them with a new leader, but it happens. But I think that that's likely to be the upshot of this. And what it means is, with the turnover of a new administration, you'll likely have a new director of the CFPB, just as you typically have a new Secretary of the Treasury, a new Secretary of Defense, but it won't otherwise block the agency from carrying out its role, its important role to protect consumers. And I think that's likely to be the case. In the book, as you know, Cary, in part 4, I talk about what it was like to be a holdover under the Trump administration, where I was a pro-regulatory, pro-consumer head of the agency, and the clear tenor of the drift of the Trump administration was pro-financial company, anti-consumer, and anti-regulatory, and therefore we took on some pretty tough battles during that year. That likely won't happen in the future. You'll have a director and an administration that are in sync from the get-go, and then when there's a new administration, there will be a new director who will be in sync with whatever changes that brings. That's my guess as to what the outcome of the case will be, and I believe it'll be a 5-4 decision. And for all of your legal beagles who are watching, my over-under on this has been that there will be at least 5 separate opinions issued by the court, because they all have their own take on these separation of powers issues, and I think they'll all want to write out their own view of what the right outcome is.
Okay, well, stay tuned. Maybe we'll have you back after June when that decision comes down.
Happy to come back and see whether I was right or wrong, and in which ways.
We'll hold you to that. No, William asks, when you look back, Rich, what do you see as your most important protections for consumers? And then also asks, have any of those been undercut by the Trump administration? And if so, how?
Yeah, I think that I generally now think, as I look back at it, that the 3 things we did that mattered the most for consumers, and there were a lot of things we did that mattered for consumers, and the book is full of interesting challenges and fights, some of which we accomplished, some of which we left partially undone, some of which we failed at. And I try to be very candid about what happened and why. But the things that we did that I think mattered the most were, first of all, the reforms to the mortgage market that I've described already. That was very significant. That was a market that had broken the economy and was in a very bad way, was very poorly policed, and had very bad regulations in place, and not a lot of restraint on some of this dramatically irresponsible lending that had gone on throughout the country. And I think we changed that, reformed it, and fixed it in ways that have been lasting. The Bureau has reviewed those rules since and largely found them to be solid. And there will be tweaks as we go, no doubt, but I think we really did very good work there. Secondly, and this is an interesting chapter of the book, it's chapter 5 on giving people a voice that matters. We had a consumer complaint function we created that allowed people to bring their complaints to the Bureau and get them handled individually at huge volumes. I mean, now they're getting more than 30,000 complaints per month. There have been over 2 million complaints over the life of the agency, and individual people who used to be frustrated when they would get cheated in the marketplace and nobody would do anything about it. Either they'd be ignored or they'd be given the runaround, now have a voice and a place they can go and often they get relief. And the other important piece of that was the Bureau learned a lot from the consumers and what consumers tell them, and that has informed the work. And then the third piece that I think was really significant was the enforcement actions we brought. We brought actions that recovered more than $12 billion for more than 30 million Americans in the first 6 years of the agency. What that means is if we recovered $12 billion for people, that means we also stopped those companies from cheating people in ways that would cost them $12 billion more over the next 6 years, and on and on. So these were big changes in the marketplace. And it also created a lot of deterrence so that companies were forced to really think more carefully about what they were doing, know that they could be held accountable, know that someone was watching. And I think it changed behavior for the better in many significant ways. I talk in the book about how I think both the credit card and mortgage markets in particular improved a lot during our time.
So one aspect of the mortgage market certainly would be disclosure of the terms of mortgages, but so much of any consumer finance arrangement deals with the terms of that lending. And Susan asks, what should we make of the CFPB's efforts in terms of simplifying disclosure across the board? She suggests and says all too often consumers do not read the fine print.
Yeah, this is an aspect of, as I talked about, how complicated consumer life has become for the average American. Consumer finance contracts are dense, they are purposely prolix and legalese, and they are hard to understand. The less you understand, the more leeway companies have to cheat you or to take advantage of you in various ways. One of the things we did, and this is chapter 9 of the book, which I called Know Before You Owe, we tried to simplify the disclosures, but clarify the key disclosures for consumers in all 4 of the main markets, that is the mortgage, credit card, student loan, and auto loan markets. And I talk in that chapter about where we had more success and where we had less success. And a lot of that had to do with the different authorities we were given. We actually had specific authority from the Congress to overhaul the disclosure of mortgages. And we had time to do it where we could really go in and test with consumers. We did consumer surveys. We actually had them read different disclosure forms and tell us what they understood and what they didn't. So we know that we improved those forms dramatically for people. And there's been a lot of satisfaction with that in the market. That's where we did our best work. In some of the other areas where we had partial or limited authority, we were able to get less done. But I think there's still future work for the Consumer Bureau to do to improve the market, specifically for auto loans and for student loans and credit cards.
And you know, another aspect of consumer lending is discrimination in consumer finance. Joshua asks about racial discrimination. Dorothy asks about discrimination against people with disabilities. What did CFPB do, or what has it done in regard to that kind of consumer finance problem?
Yeah, one of the responsibilities the Consumer Bureau has, and it shares that responsibility with the Justice Department, is to enforce the Equal Credit Opportunity Act. It means that you are not supposed to be able to block someone from credit, that is to disallow them credit on the basis of race or ethnic origin or sex or any of a number of described factors, nor are you able to charge them more for credit on the basis of those factors. The problem in this area is that many consumers don't even know when they've been the victims of racial discrimination. How would you know unless somebody actually overtly said to you, I'm charging you more because of your race? And nobody really says that anymore. And it's very rare that you would get some sort of overt statement like that. The only way really to ferret this out is to look at the patterns of lending by individual lenders and see if over time there is a systematic bias in the lending. Sometimes the lender isn't even aware of it themselves. I mean, a lender is typically a company and it's composed of a number of individuals. And some of those individuals may have stereotypes based on race or ethnic background. They may not even be fully aware of what they're doing, but they might charge people more, or they might determine that you're a less keen negotiator, so they can push you harder and take more advantage of you. It's really only in the patterns, the statistical patterns, where you can ferret that out. We brought a number of actions on my watch as the head of the Consumer Bureau, And we referred a number of actions to the Justice Department where we took action together. We brought the biggest mortgage discrimination cases in American history, credit card discrimination cases in American history, and auto lending cases in American history. One of the biggest disagreements I've had with the current leadership of the Bureau is that they have not brought a single fair lending case of that type or referred a single fair lending case of that type to the Justice Department since I left there 2.5 years ago. I don't believe that racial discrimination ended in this country suddenly when I left that position, that we had somehow cured it all. That's not a reasonable assumption to me, but they have not been vigorous about enforcing the law in that area. And it's a shame because, again, it's very hard for consumers to protect themselves. I tell the story in the book about Ramon getting cheated on his loan and not being aware of it because there was nobody to make it clear to him, and he paid more throughout the life of that loan as a result. That's a typical story, and it happens to many Americans all over the country all the time.
Go back to the enforcement versus rulemaking question that I started out with. Kenneth comments that the Dodd-Frank Act had a provision dealing with abusive behavior, and that CFPB pursued that largely through enforcement rather than through rulemaking. And he was wondering whether it would have been better to do it through rulemaking, or why you proceeded under enforcement in that case, or in other cases when you wanted to set a precedent, or maybe even, just to put it this way, set an example to others. Why not go through the rulemaking process?
Yeah, so the laws that the Consumer Bureau has available to it to enforce are of two kinds. Some are statutes that say specifically what is or is not allowed. Others are more general prescriptions, because it's been found over the years, and this predated the Bureau, that unfair or deceptive behavior, it's not possible to write all the different ways in which a company can defraud or deceive a consumer. And so you need a general provision that something that is fraudulent or deceptive is illegal, so that you can then apply it to the circumstances. That the ingenuity of mankind is so great, courts have said, in finding ways to defraud their fellow men and women, that we have to be just as vigorous in responding to them. So over the years, the term unfair and the term deceptive have been kind of worked on pretty heavily by the Federal Trade Commission, by state attorneys general, by courts, and we have a sense of what they mean, even though they're not entirely specific. They're a little bit elastic so that we can bend them to circumstances. That authority was given to the Consumer Bureau as well under our statute. In addition, as the question notes, we had authority to proscribe, to prohibit abusive conduct. And that term was a newer term, and so it was unfamiliar to the companies, and they were afraid of it. They weren't sure what it meant. Now, Congress had actually defined the term. There are two different definitions with multiple prongs, and Congress had laid out exactly what it was. So I never really understood, although we got this criticism all the time, what people meant when they said we should have a rulemaking to decide what abusive means. Congress had told us that abusive was a term, and they told us what it meant, and they gave us prongs for how to apply it, and we did our best to do that. I think what's notable is that the more recent leadership of the Consumer Bureau actually decided they were going to go in and undertake a rulemaking to determine what abusive means. And ultimately, they kind of punted on that. They didn't end up defining the term any more specifically. They simply gave some general guidance that was not even, doesn't even have the force of law, in which they simply said that they were going to be more reluctant to use that term than perhaps we had been, although we were pretty careful about using it ourselves. I think we only used it in about a dozen enforcement actions out of the hundreds that we took during my tenure.
Now, Heba asks about integrating social scientific expertise. I suppose that might be economic analysis, maybe behavioral economics, certainly, about how people make choices. Integrating that kind of research into enforcement, and how did the CFPB manage to do that? And Ronald asks a question about your views about the usefulness and appropriateness of benefit cost analysis to regulatory decision making. So I wonder if you could talk about the kind of efforts that the CFPB undertook to conduct research, to use the tools of economic analysis, and use those to make better decisions in both the enforcement context and to whatever extent you want in the rulemaking context as well.
Okay, sure. First, let me go back to the last question, because I wanted to give a much more tangible example of the abusive,
Sure.
to give people a sense of what we're talking about. I talk in the book about the Wells Fargo enforcement action that we brought, which was maybe
Right.
the known enforcement action of my era. And it had to do with Wells Fargo employees opening accounts in the names of customers without their permission, without their knowledge. Why? So that the Wells Fargo employees could make bonuses based on the number of accounts they opened. So they were opening phony, fake accounts and manipulating people's finances and their personal financial information in order to make their own bonuses and pump up the stock price. That was an action in which we brought a claim that that was abusive conduct toward their customers. And I think most people would say that's abusive conduct, that the consumer was not in a position to protect themselves against the harm done them when this work was being done without their knowledge or anybody ever notifying them about it. Now, to go to your question, Cary, question you just passed along about the use of social science and behavioral economics and also cost-benefit analysis. We tried to be very rigorous in the work we did on rulemaking and also on justifying our enforcement actions. So if we thought that a consumer practice benefited consumers more than it hurt them, it wasn't going to make a lot of sense for us to bring an enforcement action to try to stamp that conduct out. It was where consumers were being harmed, and harmed to a significant degree, that it was worth taking our time and putting our limited resources to bear on trying to stamp out that kind of conduct. In terms of rulemakings, we did give a lot of credibility to behavioral economics. That is now a recognizable form of economics. In fact, during my time as the head of the Bureau, one of our Academic Research Council members, Dick Thaler, won the Nobel Prize, shared the Nobel Prize for his work in behavioral economics. And I think that that has become part of the mainstream of the field, that consumers aren't always entirely rational, nor do they always know everything. You know, often in the economic models, the consumer is considered to be omniscient and absolutely without emotions. In fact, Thaler refers to those hypothetical human beings as econs, not humans, which he says is who we really have to work with. And they can be systematically wrong in their assessments of things or the decisions based on certain biases. A well-known one is that they tend to fear losses more than they value gains. So they are more loss averse than they are willing to risk the same amount for a gain. That's economically arguably irrational, and yet it's a common human emotive reaction. So we did think about and utilize that kind of thinking at times in our work. And I think that it was suspect to some of the free market ideologues in the Congress who were our critics because they didn't agree with that form of economics. In terms of cost-benefit analysis, our statute required us, whenever we passed a rule, to consider the costs, burdens, and benefits of the rule, how it was going to affect the industry, how it was going to affect consumers. By the way, cost-benefit analysis often puts a little bit of a thumb on the scale in a somewhat unfair way, because it's a lot easier to determine and calculate the costs to companies in terms of how much manpower might be needed to adjust to rules and how it will affect their products in the marketplace. It's often harder on the benefit side to calculate what the benefit will be for consumers. Although certainly in many of these instances, for example, avoiding future meltdowns in the mortgage market, that's potentially trillions of dollars saved by consumers who don't lose their jobs, don't lose their homes. And so it's hard sometimes to compare apples and oranges between cost and benefit. It sounds like they should be mirror images of one another, but it's not so easy. But we did our best to try to assess that in controlling the kind of judgments we were being required to make.
Another kind of technology or technical tool is artificial intelligence. And Chandra asks if you could comment on the role of AI in the financial industry with fintech and perhaps its potential for more predatory financial practices, or to at least help facilitate those. And then what about also AI in the role of the watchdog agencies, the CFPB? Is there a comparable RegTech or role for RegTech in combating fintech?
Yeah, there certainly is. I mean, one of the things that's happened in our economy, and this is this change that I said that it's occurred, this major change in the last 2 generations, that's also, of course, been the period of time in which our economy and our society has become computerized and has started to be able to cope with and handle big data sets and really develop a lot of insight and analysis out of the accumulation of large amounts of data. Both of those things are potentially beneficial. They give us better insight. We can know more than we could before. We can actually do more than before. And financial institutions understand now and are very keen to automate their compliance systems, to automate their processes so that they can know and be sure that they're not making mistakes, that things are going to be done the same way each time or within certain parameters. And there's ways to try to make sure of that and to monitor it. So clearly for a regulator, being able to oversee automated compliance gives you more comfort that there aren't one-off mistakes or errors being made as well, although you still have to go in and do some manual checking. You can't just take people's word for that. And people make mistakes, and they make mistakes sometimes in the way they automate things, not just in manual processes. So, you know, all of that is the case. AI is still a fairly new phenomenon. I don't know that we've worked out all the kinks in terms of how to use AI, how to use it effectively, and what all the benefits and the harms may be from it. It is certainly the case, and this is the worry I hear in the question that was asked, that AI as a shorthand for assembling a lot of factors and making, for example, lending decisions, could easily become a proxy for discriminatory or other prohibited decision-making approaches if we're not careful about it. We're going to need to test AI processes the same way we've tested individual subjective processes and make sure that patterns are showing up. It's not that they would necessarily be intended, but they may be the result. And if the result is unfairness to consumers, then it doesn't really matter in some ways whether it was intentional or just part of the system. It needs to be fixed.
Another innovation idea coming from Dominic, and I guess also by way, he says, of Biden, Sanders, and other political candidates, suggesting that credit reporting agencies and FICO scores get rolled into a government function, carried out by or overseen by the CFPB. Is that a good task for the Bureau to take on, or should credit reporting remain in private hands?
Credit reporting is handled differently in different countries around the world. In some countries, credit reporting is a government function. They actually handle the data and make the assessments. In America, which is often at the other end of the spectrum on these things, it's something that developed, I would say, fairly haphazardly, but developed as a private sector function. As it happens, we have evolved to the point where we have 3 major credit reporting companies and quite a number of smaller credit reporting companies. The 3 are universal pretty much. They handle the credit files for almost every American who has credit. That is TransUnion, Equifax, and Experian. What we had in place, which is true of many segments of the American economy, was not that the government itself was doing that job, but that the government was overseeing those doing the job to make sure they complied with the law. And there have been various, the SCRA, de facto, various laws that have been put in place to try to make sure that credit reporting is consumer friendly and that it is accurate and that disputes can be resolved and that people can get their complaints addressed and that the information in the files is actually accurate to you so that it is assessing your credit worthiness in a fair way. If it's not, by the way, it's a very serious problem for you. You may be cut off from access to credit and the opportunity that brings, or you may pay more throughout your life and never know it. People tend to assume that they're getting an off-the-shelf price for different loans that they get, but that's very much not the case. Those loans are determined in part by market circumstances and in part by assessments of their credit worthiness. And so these things matter, and making sure that your own credit file is accurate and complete is something that each of us should do. We should feel some responsibility to check those files, which we can do each of them once a year, and make sure that they are kept up to date. But we have not gone so far as to nationalize the credit reporting function. And I doubt that that would be a good direction as long as we can control this through regulation. But there's more work to be done to control it through regulation. We made a good start on it, but there's a lot more work to do.
So now let's turn to the current predicament that the country, the world finds itself in with the COVID crisis. What are the issues facing consumers today during the pandemic, with 38 million Americans having filed for jobless claims over the last couple of months? Lots of people in financial distress. Are there some lessons that you take from the work that you did that speak to what should be done today? This is following a question that Ben has asked.
Yeah, in fact, two of my former colleagues and I published a white paper. It's available on the platform Medium, on steps that we urged the current CFPB leadership to take in the wake of this new economic crisis, immediate steps that would help protect consumers who are in a great deal of distress right now. And you described it well in terms of the number of unemployed, the number of people who are in mortgage forbearance and potentially teetering on the edge of foreclosure. There are certain foreclosure pauses that are in place right now, which are helping, but they may or may not be effective down the road once they expire. We have had new legislation and new steps that go far beyond what we did in the last economic crisis, such as giving people forbearance on mortgages and certain amount of rent. Unfortunately, the CARES Act covers parts of the economy, but not the entire economy, so that they're not universal relief, and they're a little bit complicated for that reason for consumers to use. But we've stripped out a lot of paperwork out of that. It's much easier to apply for this kind of help. The other thing is that we have pointed out that there could be real ramifications for credit reporting and debt collection. Debt collection, many more people are going to be behind on their bills as a result of having periods of time that they were unemployed, or as we're also beginning to see more of, not just being unemployed, maybe they kept working, but their hours were slashed, so their income was reduced. People are behind on bills. There's going to be more debts to collect. Debt collectors are going to have a harder time collecting them with people in economic distress. So there's going to be a lot of pressure on the debt collectors to be more harassing, more abusive, and to skirt the edges of the law and violate the law to try to get paid. I'm concerned about that. There's more the Consumer Bureau could be doing to protect consumers in that regard, and more that state attorneys general and state financial regulators could be doing as well. In terms of credit reporting, we want to make sure that those files remain accurate. People are supposed to not be dinged for credit problems that are a result of the COVID crisis, but is that being reported correctly and being reported accurately? It requires oversight to make sure those companies are handling it well. And so these are things that I'm concerned about and writing about and urging and advocating, and we will see. Another thing that I'll mention here, Cary, and you've talked a little bit about it, is that in consumer financial protection, as in many other areas of the law, we have a federal system in this country. Not only the federal government, but the state government has role and authority to play here. I've been working with the state of California to try to put in place a state-level agency that's similar to the Consumer Financial Protection Bureau, overhauling the Department of Business Oversight. The governor has put that forward in his budget proposal. It is in front of the California legislature and will be acted on this summer. and could represent a very significant advance in consumer protection at the state level to go with the federal level, or perhaps to step in where the federal authorities aren't doing their job to the extent that they might be otherwise doing it.
So if you had your druthers and you could have Congress pass legislation or pass appropriations, what would be the priorities going forward to give the CFPB the resources or the authority that it needs to address these kinds of broader powers? Or do you think that things are right about where they should be? Perhaps I would imagine, if it were a different administration with a more wielding the existing powers of the CFPB in a more, pro-consumer manner. Or what do we need to do going forward, do you think, that would be helpful for the consumer?
Well, in terms of the authorities of the Consumer Bureau, I've thought a lot about that over the years because we might have been very frustrated at the fact that we wanted to do things and we couldn't do them. I think that Congress did a tremendous job in setting up the agency and giving it the right authorities to address these problems. I think both Representative Barney Frank and Senator Chris Dodd, who were the leaders on this legislation, just did an enormous service to the American public by handling that legislation as well as they did. What I would also say is there are certain areas where we did have some frustrations. In auto lending, auto dealers got themselves carved out of the statute. They exercised their political muscle in Congress, which they have every right to do, but it certainly impeded our ability to address some of the problems in the auto lending market. Also, the Bureau had clear authority over private student loans, but the authority was more blurry in terms of federal student loans. Now that that market has become mostly a federal student loan market, we relied significantly on close cooperation from the U.S. Department of Education to be effective. And we had that during the Obama administration, but once the Trump administration came on and Secretary DeVos at the Department of Education was not willing to cooperate any further and actually ripped up the memorandum of understanding that we were required to have with the Department of Education and has not been a good colleague since. That's impeded the Consumer Bureau's ability to address some of the student loan problems. And some of that work has moved to the state level where there's a student loan borrower protection project working with different states to try to make sure that students and their families are being protected against abuses in the student loan area. But I would like to have seen the Consumer Bureau have more explicit authority in that area, and that would be a potential change.
That's great. Well, listen, we are just about at our final closing time here. Do want to remind anybody taking the webinar for CLE credit that the second code is in the chat function. If I could ask you, Rich, just very briefly, for any of our students who are participating on our webinar today, can you offer some brief closing words to them about how they should think about their future and particularly the role that performing public service might play in that future?
Sure, I'd say two things. First of all, I do think that this book that I've written is a good guide to what it's like to take on some of these fights in government and some of the fascinating issues of consumer finance that are very much a part of our everyday lives today. And I think that it's a good read, a quick read, and a good accessible read for students. The other thing I would say is it tells a story of how a government agency came to be pretty effective at dealing with some difficult problems against some powerful adversaries. And it is a model for what could be done to try to align the government more behind the public interest as opposed to the special and private interests. We often deplore a rigged system in Washington, and there are reasons to be concerned about that, gravely concerned, because of all the power and influence that's brought to bear there. But this is an agency that rebalanced the scales for the American public, for people in our communities and our neighborhoods, and the same could be done throughout the government, I believe. So it's a roadmap not only for the future of the CFPB, but the future of government efforts to create fairness for the American people, which is something we should all be behind.
Well, once again, the book is Watchdog, Rich Cordray, thank you for being here and talking about the book. And thank you also for your leadership and your public service. And thank you so much for spending time with us over the past year at the University of Pennsylvania Law School and the Penn Program on Regulation. I'm Cary Coglianese. I've been pleased to moderate this discussion. Rich, it's been great to see you again. And I want to thank all of our audience members for joining in on this important conversation today. Thank you again.
Thank you all.